Welcome to our SIENNA webinar, where we'll today share snapshots of our legal research into AI, robotics, human enhancement, and genomics. My name is Rowena Rodrigues. I am from Trilateral Research, and I'm the Deputy Coordinator of the SIENNA project. And on behalf of all the project partners, welcome you today. The SIENNA project is a EU-funded Horizon 2020 €4 million project with 12 international partners. And what we are doing in the project is we are developing ethical frameworks and tools for AI and robotics, human enhancement, and human genomics. These are the three main technological areas that it addresses. And the project is a 3.5-year project, started in October 2017 and ends in March 2021. So who are the consortium partners? The SIENNA project is coordinated by the University of Twente. We have 12 international partners from Europe, Asia, America, and Africa, and these include 9 universities, 1 SMU, 1 Association of Research Ethics Committees, UREC, 1 civil society organization, Helsinki Foundation for Human Rights. The genomics work package is led by Uppsala University, AI and robotics co-led by the University of Twente and Trilateral, and human enhancement by the University of Twente. So the project objectives, we have 3 core objectives, and these are firstly to develop ethical frameworks that address present and future ethical issues in the 3 technology fields, taking into account stakeholder and public views and existing legal and human rights frameworks. The second objective is to then translate these frameworks into ethical codes for researchers and innovators, operational guidelines for research ethics committees, and proposals for revision of existing ethical and legal frameworks. And thirdly, to generalize these approaches for developing and translating and adapting ethical frameworks that we had established so that they can be applied to new and emerging technologies. What are our achievements and ongoing work? We've carried out various activities in SIENNA so far, including a state-of-the-art review of the 3 technology areas. We've done a mini socio-economic impact assessment and a foresight analysis of possible future developments and impacts, looking at and using expert consultations. We've conducted a legal, regulatory, and human rights analysis, which we are presenting today. SIENNA has also identified and analyzed ethical guidelines and codes at the international level. It has also carried out public opinion telephone surveys to understand public views and awareness of the 3 technologies in 11 countries, inside the EU and outside. We also have carried out panels of citizens in 5 EU countries, namely France, Germany, Spain, Poland, and Greece, with around 50 participants, including members of vulnerable populations in each country, to discuss the impacts, ethics, legal implications of genomics, enhancing human abilities, and AI and robotics. Then we've also carried out an ethical analysis and evaluation of the 3 technologies based on our previous work, using desk analysis, using expert workshops. And now we are at the critical stage of the project where we are developing our proposals for new ethical frameworks and guidelines and improving existing ethical and regulatory frameworks. I will now speak to you about the legal analysis of AI and robotics, and then Konrad from the Helsinki Foundation of Human Rights will present the results of the legal analysis work in human enhancement. And finally, Santa Slokenberga of Uppsala University will present the legal analysis of human genomics. We will have some time for questions at the end of the presentations. The main goal of the legal research of AI and robotics was to identify, discuss, look at legal developments and legal issues and human rights, along with the gaps and challenges related to these areas at the international, regional EU, and the national level. So we looked at 12 countries in the EU and outside the EU. The 12 countries were Sweden, Netherlands, UK, Germany, France, Greece, Spain, Poland, United States, Brazil, China, and South Africa. There were 5 key steps in our legal analysis approach. The first was to identify the legal issues and challenges related to AI and robotics. So we carried out a literature review of AI and robotics documents, looking at the legal aspects, articles in academia, in legal practitioner journals, books, commentaries or policy studies from the last 5 to 10 years to determine what are the legal issues that are being discussed and debated and need to be further explored in SIENNA, and particularly in our country studies. Then we looked at the relevant international and regional EU laws and human rights standards using desktop research. So we looked at what are the key organizations in the area, explored the scope of their mandates, what work they are doing. We mapped the international sources of hard and soft law and looked at the application in terms of AI and robotics and determined the gaps. Then we used a mix of some criteria to determine which specific issues we should look at the country level. And these criteria included the prominence in legal and policy discussions at the international, regional, or national level, the prevalence of such issues in the discussions, their potential to impact ethical values and human rights, and the novelty and need for further research in the areas. And using these criteria, we shortlisted two specific topics of study, each for AI and robotics, and I will outline which a little later in the presentation. Then we also carried out a national comparative analysis. So using the country reports that we prepared, we kind of did a horizontal comparison that looked at what were the research results, what are the common themes, and what is coming out from these countries. The purpose of our horizontal comparison was to kind of help broaden our sight, widen our horizon, and see things in perspective in relation to the research on AI and robotics in the legal field. And then we identified the gaps and challenges, and these were connected to either sufficiency of policy and the laws and their application and or interpretation. So what are the legal issues and human rights challenges of AI? As we can see, there are many of these. So for example, lack of transparency, unfairness, bias and discrimination, very well talked about. Lack of contestability, there are IP issues, legal personal issues, cybersecurity issues, issues related to impacts on workplace, privacy, data protection, issues related to liability and accountability for harms. And some of these issues relate to the design and nature of AI itself. Others are connected to its implementation and use. These issues could be cross-domain, could manifest in more than one sector or field, or they could be common to all technologies, for example, privacy. Many of these are interrelated at times, transparency, fairness, and don't operate in silos. And some of these are novel, for example, legal personhood for AI systems and robots. From these wide variety of issues, we then selected two specific issues for study at the national level. So these were algorithmic bias and discrimination and intellectual property issues related to works created by AI. With regard to robotics, we looked at the legal issues and human rights challenges as well, and these included deception by robots, legal personhood, use of autonomous weapons to kill, harm, or make threats of harm, safety and control issues, liability issues for malicious and non-malicious use, replacement of human workers, job losses, privacy invasions, consumer protection issues, intellectual property issues. And from this variety of issues, we then selected two specific ones for study at the national level. These two were creation of a specific legal status for robots, i.e., has the law created or does the law recognize a specific legal status for robots? Are there movements in this direction at the national level? And the second issue was safety and civil liability issues. Who is liable for damage caused by robots? So here are some key findings that the report presents, and I've just presented a few here because there's very limited time to take you through these. At the international level, so we see that issues are covered in a general sense by international law provisions with a few natural exceptions, either because they are regulated at the regional or the national level. At the EU level, what we see is data protection law might provide a good basis to deal with many of the issues, but effectiveness of data protection law depends upon its use. There is also what we see a discrepancy in the approaches and recommendations of the various EU institutions, for example, at the parliament level, at the commission level. And yet what we see overall is a general proactiveness in terms of policy and legislative developments. At the national level, what we see is that legal discourses are more established in some countries than others. At the time of writing of the report, there were no significant or major amendments in legislation on constitutional or human rights with particular reference to developments in AI and robotics. In most cases, what we see advocate is a cautious response to the regulation of AI and robotics. And at the time of the research, again, no new regulatory bodies had been created to specifically regulate AI or robotics, though several calls and proposals have been made. And it is worthwhile to look at the legal analysis report and the country reports for further details on these findings. So what are the gaps and challenges? Our research shows that there are few AI and robotic specific regulations, except in limited cases, for example, autonomous vehicles and drones. This is both an advantage and a challenge, as existing laws and regulations which address such issues directly or indirectly may often fail to take into account what are the creative uses and impacts of AI on individuals and society. Secondly, we have what was highlighted was the lack of regulatory bodies, and this is especially relevant because strong calls have been made for such bodies where existing regulators fail to cover the remit of new impacts and effects of AI, for example. Then there is the issue of sufficiency and adequacy of existing national laws. This has been questioned. For example, the Swedish national report points out that, yes, of course, existing law could accommodate issues of discrimination. Whether it is suitable means to tackle the issue is a whole other matter. And similar in cases of other country reports, this has also been highlighted. Also, for example, the German report points out that existing regulations are not adequate in the sense that perhaps it is too soon to tell whether the new data protection regulation would be sufficient to protect privacy in this context. There are also differences in the nature and sophistication of the legal academic debates in some countries on AI and robotics. In some cases, like Poland, these have been found to be clearly lacking. For example, the China report also highlights the need to continue to strengthen frontier research and discussion on legal issues related to AI and robotics, and the need to kind of provide resources for future legislation and judicial trials that pertain to AI and robotics. Another highlighted challenge was the lack of judicial knowledge about how AI and robots work and the need for proper training, and this came out in the context of the Spanish country report. There is also the issue of grayness regarding the liability of robots and automated systems. This is a particular challenge, and it also boils down to the conflicting views that exist on legal status, and many of these questions remain unanswered. There are wide-ranging societal and human rights implications of AI and robotics. As we see, they will affect a spectrum of human rights: data protection, equality, human dignity, human safety, privacy, justice. And what we see is these technologies have the potential, because they work closely together and with vast amounts of data, they will have crossover and multiplicative effects which then exacerbate legal and human rights issues. And if the AI and robotics industry continues to develop applications and systems without paying attention early on in the design process to the impacts of such technologies, then we have a problem at hand. So there is a definite need to set clear ground rules on what AI and robotics applications are not permitted. We need a drawing of red lines where required. We also need to determine how to address the negative impacts caused by the import and export of such technologies. And in particular, we need to pay attention on the global impacts of AI and robotics, particularly in relation to vulnerable international communities that need protection. And finally, just to share we are happy to say that our work is feeding into other related projects like the Sherpa project that is looking at AI and big data from the ethics, human rights, and security perspective. And also, we hope to continue the work that we have done in SIENNA in the context of other new technologies. And we've also shared this at the European Commission level. And we hope this research will be useful in your work as well. Thank you. I now hand over to Konrad Siemaszko, who will talk about legal analysis of human enhancement.
Great. So once again, my name is Konrad Siemaszko. I work for the Helsinki Foundation for Human Rights, and I'm going to present the SIENNA work on the legal and human rights requirements for human enhancement technologies. The report itself was prepared chiefly by my colleague, Zuzanna Warso. But first, what are human enhancement technologies? Human enhancement remains a disputed concept, but within the SIENNA project, we have adopted in the previous stages of the project the following definition. Human enhancement is a modification aimed at improving human performance and brought about by science-based and/or technology-based interventions in or on the human body. Analysis of the legal and human rights requirements of the human enhancement technologies follow the same objectives and research questions as in the two other technological areas studying the project. We have first identified legal issues raised by human enhancement based on a literature review. Then we've analyzed relevant international and regional norms with a particular focus on the EU level. Furthermore, based on the common guidelines, 12 country reports were prepared on both EU and non-EU states that you can see on the map on the right. And having identified some of the challenges and gaps, we have also formulated some preliminary recommendations on the possible ways to address them. We have identified 7 broad categories of issues, starting from the appropriate level of regulation for the pre-market approval that ought to govern human enhancement technologies, with a distinction between devices and drugs. Though these two groups don't encompass all classes of human enhancement technologies, they do represent a demarcation that is currently recognized by law and largely followed by legal scholars. For instance, we've noticed a discussion whether a threshold for approval for human enhancement devices should be stricter, less strict, or equally strict as for the medical devices. Should the acceptable risk be lower, since there are no clear medical advantages that justify the risk, or on the contrary, since there are no medical needs in the sense of a necessity or pressure, then the acceptance of the risk is more of a matter of individual choice. Other issues included the questions of civil liability. Once the human enhancement technology is already on the market, that questions who is liable for the harm that occur as a result of their use. They implicate possibly both the product liability issues for harms caused by a defective product, and they may implicate professional liability issues, given that they may include services offered by medical professionals or other professionals. There's also a number of legal questions regarding the ownership of enhancement devices that have been incorporated into a human body, or questions whether such technologies may be patentable. Human enhancement raises also some security concerns that have potential to implicate criminal liability. For instance, with regard to unlawful access to implants, or denial of service attacks on implants, or misuse of personal data collected by enhancement wearable devices. There's also a whole area of employment law issues and family law issues. For example, employees may feel pressured to enhance to remain competitive on the market. And it seems prima facie that the status of being enhanced or not being enhanced is currently not included in the protected characteristics, so there's the risk of discrimination. And of course, there's a number of human rights challenges, starting with the general principle of dignity and principle of self-determination, up to more specific issues such as right to privacy, protection of physical and mental integrity, data protection, or protection from discrimination. And to provide you some snapshots of the results, the analysis has indicated a common thread at all 3 levels: international level, regional level, and national level. How to balance guarantees of individual autonomy with a need to ensure safety while also remaining mindful of wider societal impacts of human enhancement technologies. The international human rights norms provide some guidance, but only to a limited extent. Although they constitute an important normative anchor point, the exact scope of human rights with regard to human enhancement is still yet to be determined. We need to wait for relevant case law, perhaps for specific dedicated soft law, or even for more legal scholarship on these issues. In the European Union, there's also an additional challenge. Question what should be left for the member states to regulate, and what should and could be harmonized at the EU level, taking into account the principle of subsidiarity as well as the risk of disparities between the member states. Currently, internal market law remains to play the central role of the human enhancement regulation, as human enhancement products in principle fell within the domain of free movement of goods, while the applications of human enhancement, the human enhancement procedures, principally remain within the scope of member states' competences. It has also noticed that criteria used for approving products on the market are mainly limited to assessment of medical risks and benefits. In principle, the assessment does not consider other ethical or human rights risks. Moreover, in many jurisdictions, there's a recurring challenge of providing a clear demarcation between treatment and enhancement, what is not only a theoretical issue, but what may give rise to a gray zones where it is unclear which legal provision should apply, what standards of care should apply, or what standards of accountability. Having identified some of these challenges, we have also proposed a few preliminary ideas on the way forward. The right to physical and mental integrity, as envisaged among others in the EU Charter of Fundamental Rights, may play a guiding role in the efforts to regulate human enhancement, as human enhancement occurs via intervention in or on the human body, as well as since the right to physical and mental integrity is in itself a cluster of rights relevant to human enhancement, such as it includes such rights as the right to privacy, prohibition from treatment, and the right to health. Having in mind a number of issues that the human enhancement products may raise, it may be worth to consider a more nuanced approach to risk-benefit analysis, to consider a model that will encompass in the assessment different ethical, societal, and human rights impacts, not only medical safety and efficacy issues. Having said that, safety remains one of the key issues, and is especially crucial to protect it in the gray zones I've mentioned, in the field of providing human enhancement services or procedures. It is needed to guarantee that individuals undergoing these human enhancement procedures will benefit from the established safeguards in the biomedicine field, such as the right to obtain clear information about the risks involved in the procedure, or the requirement that the procedure, human enhancement procedure, is conducted by a trained professional who can be held accountable. And as a final remark, regulating enhancement, it is important to keep in mind that different human enhancement products, procedures, entails different types of risks and different level of risk. So again, it's crucial to keep a nuanced approach and perhaps develop a categorization based on such criteria as enhancement invasiveness, complexity, whether it's permanent, what kind of health risks it might entail, and also its social acceptability. Thank you for your attention. I'll be happy to answer your question afterwards. And now I'll be handing over to Santa Slokenberga for genomics.
Thank you, Konrad. Hello, everyone. My name is Santa Slokenberga, and I have been leading a task on law and genomics, and it has resulted in the deliverable that I am now presenting, analysis of the legal and human rights requirements for genomics in and outside the European Union. The overall aim of this study has been twofold. First, to examine how the law currently responds to advances in the area of genetics and genomics, and identify what challenges, limitations, and gaps emerge. Secondly, to identify key human rights norms and regulatory approaches that could be examined further for shaping legal responses to the new and emerging technology in the field. Our research has been guided by the following 5 questions. Firstly, what are the international and regional laws relevant to human genetics and genomics, and how they respond to challenges posed by scientific advances in the field? I will talk about these challenges shortly, but here I just want to mention the area of inquiry and the focus of the regional legal orders that we've had. We've focused on the United Nations, on UNESCO, on the Association of Southeast Asian Nation States, on the legal responses within African Union, Council of Europe, the Organization of American States, as well as the European Union. Our second question has been, which rights may be potentially affected by these developments in the field, and what standards might be relevant to consider? Our third question has been, to what extent the existing legal frameworks are adequate to deal with challenges that are posed by the developments in the field? Our fourth question has been, how are specific legal questions addressed in different jurisdictions, and what are the commonalities and differences that emerge? And here specifically, we have done in-depth studies in 12 countries, 4 outside the European Union: Brazil, China, Japan, South Africa. We've also accounted a little bit for the US, which makes it the 5th country outside European Union. When it comes to the European Union, we have focused on France, Germany, Greece, the Netherlands, Poland, Spain, Sweden, and the United Kingdom. And finally, our question has also been, what are the convergences, divergences, and gaps in national and international legal orders for genetics and genomics? And of course, what are the possible ways forward to overcome these gaps? Our approach consisted of 5 interrelated steps. Firstly, to identify legal issues and human rights challenges in the area of genetics and genomics. Secondly, to analyze relevant international, regional, and human rights standards. Thirdly, to study specific issues at national level. Fourthly, to carry out comparative analysis. And finally, to identify gaps and challenges, as well as to provide some guidance for further work in SIENNA project. At the nucleus of SIENNA study were 6 main questions. Likewise, we also gave possibility to our national partners to report on any other issue or area of concern that has not been covered by these 6 questions. Firstly, we've been curious how, if at all, human germline gene editing is regulated. Secondly, we've been interested in what are the legal rules applicable to governing genetic screening as part of public health measure. Thirdly, we've been interested in the legal rules applicable to genetic testing. Fourthly, we have been specifically interested in the rules relating to prenatal genetic testing as well as newborn screening. And finally, we have been curious about the legal standards when it comes to advertising of genetic testing, more specifically direct-to-consumer genetic testing. And now we would like to share with you some observations, gaps, and challenges that we've found in our study. The first conclusion that characterizes human germline gene editing, but it could relate, in fact, to any of the areas of inquiry, is that there is fragmented regulatory landscape. And when it comes specifically to human germline gene editing, the fragmentation relates to, for example, whether the laws are able to accommodate prohibitions for human germline gene editing as such, or they focus only on specific activities, such as clinical trials. And here, member states of the European Union that are not member states or signatories to the Biomedicine Convention are at a particular risk of having covered only one dimension in their national laws. Likewise, fragmentation relates to the different legal standards regarding various steps in human germline gene editing question. For example, to what extent human embryo research is allowed, what prohibitions, protections, and limitations are put in place. We've also identified that there are many technological advances that have the potential to lead to improved health outcomes. However, what concerns the realization of the right to health is commonly done at the national level with due regard to the availability of resources. This situation opens up for further discussion between developing advances on the one hand and accessing these advances on the other hand. And of course, when it comes to access, also this question of social justice comes into play. A prime example of such technology is genetic screening as a public health measure, which, as we see now, is underused. Genetic testing, mainly due to the character of genetic data, raises a specific set of legal issues. Human rights law provides a certain degree of guidance on how to address them. However, nationally, requirements and consequently protections to the individuals tend to differ whether testing is carried out in a clinic or outside it, usually leaving the latter group unprotected. The question of direct-to-consumer genetic testing and advertising of direct-to-consumer genetic testing allows doing a simple observation. This is a maturing phenomenon, if not already an aging phenomenon. But in many cases, we don't have adequate laws in place. The response to a question under what circumstances, if at all, advertising of direct-to-consumer genetic testing should be permissible is not straightforward. It is autonomy as well as self-determination and aspiration to protect from risks and safeguard genetic privacy that are among principles and rights that are colliding here. At least when it comes to the countries of the European Union and European Economic Area, when it comes to quality of these tests, with 2022 May, this question will be to some degree resolved. However, not necessarily when it comes to access to these tests. Therefore, national self-determination in the area is crucial. A recurring question in the area of prenatal screening is the balance between reproductive autonomy of the pregnant woman or the intended parent on the one hand and other rights and interests the state is aspiring to protect. To date, there are countries that enable or at least do not hinder access to prenatal screening, but severely restrict women's reproductive self-determination, for example, through criminalizing access to abortion. And when it comes to newborn screening, while newborn screening has a clear right to health benefit, at the same time, it opens up for questions regarding genetic privacy and decision-making regarding access to genetic information and participation in scientific research, among other questions. As the scope of screening will advance, this can put the right to genetic privacy, including the right to choose if to access one's genome, at stake. Now I would like to share with you some of the conclusions we have made within the project, as well as considerations regarding possible ways forward. Scientific advances in the area of genetics and genomics challenge a number of human rights. The survey of human rights instruments that we have done in the project, as well as national legal frameworks, in particular constitutions, show that in most of the cases, the human rights are shared. What differs is interpretation and application of these rights. Therefore, it is our finding that human rights norms provide for an important point of reference for shaping legal responses in the area, but for many cases, it will be a starting point only rather than a closing argument. In many cases, more precise responses will need to be found with due regard to principle of proportionality and balancing of competing rights and interests at stake. This suggests to us that any regulations at the beyond the state arena risk remaining at the principle level only and be constrained to the minimum of what the states can agree on. It could, however, not necessarily be easy to find such points of agreement. As the review of human rights instruments has shown, human dignity, for example, is a shared value in all human rights legal orders as well as the European Union. However, whether or not human dignity protects human genome from heritable editing and under what circumstances is a matter of interpretation. Genomics is a rapidly developing area. Whether everything that is scientifically possible and could be relevant to furthering health should in fact be applied to humans. This is a question that still needs to be tackled, and in that regard, in our view, the right to science is an area that should be further scrutinized. And we call for more nuanced understanding of this right. In our view, these findings could inform the right to health as well as the protection of a number of civil and political rights human genetics and genomics trigger. A recurring question is genetic information and genetic data in terms of access and protection. In our view, reconceptualization and understanding of access to genetic information and the development of personalized medicine could give rise to considering whether access to one's genome should and could eventually be enshrined in the human rights instruments. This understanding could affect legal frameworks on genetic screening and testing at various stages of human development. When it comes to genetic data, it is our belief that their value is debated a lot, but it still needs to be reassessed. Many of the reviewed legal orders have done and have gone in the discretion of setting for stringent protections. In our findings, we dare to question whether more protection or heightened protection is indeed the right or the necessary way to go, or if there are any other alternatives that could and should be examined. For example, strengthening protections against misuse of these data, instead limitations on access and their use. Lastly, not only what to address, but also how to address is important. Our national studies have shown that considerable challenges exist in responding to new technology in the area. And these challenges emerge not because the lawmaker would have deliberately created them. They commonly appear as deficiency in constructing a particular legal provision in a way that it is not capable of accommodating technological developments in the field and diverse applications. For example, often the law addresses only health-related application of genetic and genomic technologies, but not the application of technology as such outside health context. These reflections speak of principle-based and not application-based regulatory norms. However, these modalities also require reconsidering periodic revisions in light of the duty to respect, protect, and fulfill human rights, as well as to ensure effective oversight and enforcement of the legal requirements. This is something we've observed that as of now, many legal orders have some provisions in place. The oversight and enforcement is missing. More of our conclusions can be found at the very end of deliverable 2.2, as well as some of the work has been made available to scientific community and more is expected to come. We hope it will be useful in your work in the future. With this, I thank you for listening and I hand over to Josephine for managing questions.